Awesome. Well, thank you all for joining. I'm Alex. I am the co-founder of Sprintlaw, and today's presentation is entitled New Unfair Contracts Laws. Is your small business safe? Before we dive into the legal details today, just to introduce you to Sprintlaw, for those who don't know us already, Sprintlaw is an online law firm really designed to make legal services easy, simple, affordable, accessible for startups and small businesses. The way is quite different to traditional law firms. We don't charge by the hour or anything. Our lawyers all pretty much work on a fixed fee basis. So if you need legal help in any of the areas in which we work, whether it's with contracts, privacy, getting your business set up, employment law, pretty much anything that you might need lawyers for, we'll always give you a fixed fee quote, and that's kind of the cost of the service. And we have an optional membership, but about 90% of our clients sign up to it. It's a really great way to get access to ongoing help for your business. There's a ton of tools in there, to manage your signatures, build your own free documents. There's AI stuff to get quick answers to legal questions. You also get access to a helpline where you can book unlimited quick calls with lawyers for quick questions. And then it's included in the membership in case you need expert legal services. So it usually pays for itself if you sign up. So I would encourage those who haven't signed up to consider checking it out. A bit more about us. We've been around for about 8 years now. We are one of the fastest growing legal businesses in Asia Pacific. We have a bit over 8,000 clients, lots of happy customers, won lots of industry awards. And we are originally from Australia, but have also expanded now to New Zealand and the UK as well. And if after this session or otherwise you have some legal questions, you want to get a contract checked, we'll drop a link in the chat. There's a QR code here that you can scan. I'll show it again at the end as well. You can book in a free chat with one of our team, and we can potentially help with some questions that you might have about contracts or otherwise. So today we're talking about the new unfair contract laws. Now, when I say new, they're not actually that new anymore. They came into force in September 2023. About 18 months ago now. And in fact, unfair contract laws had been around for many years before that, and the penalties just got more severe a bit over a year ago, and now they're starting to be enforced. So many small businesses haven't really had their contracts looked at in a while. Many people aren't aware, even if you got your contract prepared recently, of how these laws work. And while some of the impact of these laws comes down to the wording of the contracts that you're using in your business, some of it is actually just general knowledge stuff that you should be aware of when you're signing deals, to know what you should and shouldn't be signing, and also to make sure that when you're explaining contracts to your customers, you're not explaining it in a way that might breach these laws. So it's fairly new rather than brand new is how I would describe it, but it's really starting to take shape now, and we're starting to see the regulator, ACCC, start to enforce some of these laws. So it's a really good time to get across them. So in this prezo, we're going to cover what are these unfair contract terms, what does this thing mean, and how does it affect your business and your contracts? What are the new or more recent laws, and how might they impact your business? We'll go through some case studies, so some actual examples of things that you might have seen in contracts, or maybe you even have in your contracts, that are potentially or likely to be unfair under these laws. And then we'll go through quickly some next steps, basically how to avoid having issues in terms of breaching these laws. As I'm going through, if you've got specific questions, do feel free to use the Q&A feature in Zoom to ask a question. I'll leave a little bit of time at the end, but I don't mind answering as I go through as well. It can also be nice while we're talking about the topic to answer some questions. So do feel free to ask them. So let's start with the basic question. What are unfair contract terms? So unfair contract terms are terms that businesses may put in their contracts, which are seen by this piece of law to be unfair. And the definition of unfair is not super clearly defined in the law. It's somewhat qualitative, but it's defined as clauses that create a significant imbalance in the parties' rights. So one party to the contract is in a much better position than the other one. That imbalance is not necessary to protect the legitimate interests of the person who's asking for that imbalance. And if enforced, it would cause detriment to the other party. So basically what we're talking about here is, you are getting someone to sign something, or you've been asked to sign something which is, very much in one person's favor, which is, if you're asking them to sign it, maybe your favor. And if it's too far in your favor, it can be seen as unfair, and therefore you would be in breach of these laws. Now, these laws don't apply to every contract. The law is happy for you to negotiate, a custom or tailored deal with a partner, a customer, whatever it is, where you negotiate it and you come to some sort of agreed outcome. It's really intended to apply to standard form contracts, the contracts that are being signed every day where people aren't really reading them closely. The terms and conditions that might be on your e-commerce website and people just tick the box without reading them, or the contracts that you get all your customers to sign, which is in a standard format, and they just sign it and you just say, here are my terms, but you don't give them an opportunity to negotiate. This is the universe of contracts that the law is designed to protect. And you can understand the kind of policy reason for this. More and more transactions and deals are happening electronically now. Less and less people are reading what they sign. And so the law is really designed to prevent someone from kind of unknowingly signing something that's really bad for them and having it used against them when they didn't really realize. And so if you're running a business and you have customer contracts and you have all this stuff in the fine print that protects you, and people aren't reading it, then you could be at risk of potentially breaching these unfair contract terms, because that's exactly what it's designed to deal with. Now, the new law, unfair contract terms have, for a long time, these laws have been around for a while. The consequence of having them in there, it wasn't a massive risk for you, the business. If you had some unfair stuff in your contract, all that would happen is when you tried to rely on it, if the case went to court, a judge might say, look, that's a bit unfair. We're not going to enforce that clause. And so that was the consequence. It might not work, but that they kind of ended there, if that makes sense. Under the new laws, instead of it just not being enforceable, in fact, you can be penalized. There can be fines issued by the regulator just from the mere fact of including it in your contract. If you have some stuff in your agreement that seem to be unfair, the ACCC, the regulator, can say, hey, this contract, not only are we not going to enforce these one-sided clauses, we're actually going to fine you for trying to get people to sign up to them. So the stakes are significantly higher. And, for us as lawyers and lawyers across the profession, it really has changed the way that we write a lot of our customer agreements. Prior to these laws coming into force, we would write for our clients fairly aggressively one-sided contracts, particularly when they're standard form, because we want to protect our clients' interests. And we would say things like, to the maximum extent permitted by law, X, Y, Z, we will not be liable for anything that might go wrong in the agreement. And we wouldn't shy away from putting in one-sided terms, because we knew that the only consequence, if they were deemed to be unfair, they would be struck out. But you may as well have a crack, was sort of the logic in the legal profession. Now, that kind of language that was used by most lawyers in standard form contracts is not okay. It's not that you can just have a go, and if it doesn't work, it doesn't work. If you actually have that language in there, you can be fined or penalized. And so we'll come to this in a bit more detail, but pretty much anyone who hasn't had their contract looked at and it was prepared before late 2023, there's a reasonable probability that you have some stuff in there which needs to be changed because of this quite significant change in late 2023, if that makes sense. So as I said, it went from being unenforceable to actually being finable, and that's why we're making a bit of fuss about it, and also applied to a wider scope. So I said before, these things are about standard form contracts. They don't necessarily apply to stuff that is negotiated. If you want to do a custom deal with someone, which is a bit one-sided, but everyone has specifically agreed to it, these laws aren't designed for that. They also had only been designed for small business contracts, but the definition of that has changed. And again, we'll come to that in a little more detail in a moment. So do these changes impact you? Some questions you can ask yourself is, do you as a business have a standard form contract that your clients are signing and accepting? A lot of businesses do. If you're a services business, it might be your services agreement, your client agreement, your business terms and conditions. If you're an e-commerce business or a goods business, it's your T's and C's. If you're a software business, it's your SaaS agreement. Whatever, if you have a standard contract of any type on your website or otherwise, signed or tick box acceptance, whatever it is, this stuff might apply to you. Is the person that's signing it, is the second question, a consumer or small business, which is very broadly defined. So we'll come to that in a moment, and that's been expanded. So for most people, the answer to this question is maybe or yes. If you only work with really, really big businesses, then maybe it's okay. But for most, given the broad definition, this might apply. And finally, have you had it looked at, as I said before 9 November 2023? Chances are, if it was written after November 2023, certainly if it was written by Sprintlaw, we from late 2023 onwards started. It may be okay, but if you haven't had it checked from before then, or it depends on who prepared it or used an online template or something, you might want to then have it checked. Just had a question come through on the chat. If I understand the contract and sign it, can I still rely on the UCT laws to avoid it? It's an interesting question. So if you or your customer or whoever has read a standard form contract in detail and it had some one-sided stuff in there, and later on you or they want to say, actually, this is too one-sided for XYZ reason, the mere fact that you've read it doesn't preclude you from saying it's unfair. You can still say that it's unfair. The law is designed because a lot of people aren't reading the terms and conditions, but it's not a prerequisite that they prove that you didn't read it. The law is just really about what do the actual words in the agreement say. And if they are seen to tick these boxes, then whether or not the person read it doesn't really matter. Now, of course, if you read it and chatted to the vendor about it and they gave you an opportunity to raise concerns, someone could argue maybe it's not a standard form contract, it's a negotiated agreement. So again, if you've got some one-sided clauses, but the way that you deal with your clients is, you always take them through the term, ask them to let you know if there's any issues, you tell them you're happy to change things if they've got any big issues, then you might be able to say, well, this wasn't a standard form contract, and so the unfair contract terms don't apply. So there is a little bit of a nuance to your question, but in general terms, the mere fact of reading or not reading doesn't matter. It's just about the wording as to whether it's unfair. So I've alluded a couple of times to there's this other thing where it not only has to be standard form, it's with consumers or small businesses. Previously, the definition was still pretty broad, but not super broad. It said UCT laws only apply if one party has 20 or less employees, or the upfront price payable is under 3K, or if it's an ongoing contract, 1 million for contracts lasting more than 12 months. Now they've simplified it. Basically, the UCT applies if one of the parties to the agreements, any party to the agreement, has less than 100 employees or make less than 10 million. So if you are bigger than this and the other party is bigger than this, then these laws don't apply to you. But certainly for most of our clients at Sprintlaw, this is true, and they are often dealing with clients for which this is true. They're either consumers, or if it's B2B, it's in this raise. So that's why I said it's pretty likely, if you use standard form contracts, that you're going to tick the box of it being for consumers or small businesses. So again, that's kind of how that aspect works. And in terms of the penalties, I've kind of covered this a little already, but previously, prior to September 2023, the only consequence of having one of these one-sided clauses was that you couldn't rely on it, you couldn't use it against the customer, but otherwise the contract still worked. There were no financial penalties. But the big change, which happened in 2023, and there's now starting to be cases where this is being rolled out against larger and in some cases smaller businesses, you could be fined by the ACCC quite significantly. I mean, the penalties can be up to $50 million for businesses or $2.5 million for individuals. And, it can be penalties can be applied again and again and again. So if 10 people signed unfair contracts, it could be times 10. Now, they're not going to give a $50 million penalty to a small business. The actual calculation of the penalty is often based on the size of the business. But in a few of the penalties that we've seen be handed out, they can be pretty severe, and in some cases nearly business ending. So it might not be 50 million, but it could be in the hundreds of thousands, depending on how big your business is. And again, it's a pretty severe consequence. So if you want to sleep easy at night, you want to make sure that your contracts don't have anything that could subject you to these fines. And yes, this is sort of what I just said. If you have 50 clients, you can be penalized times 50 for each instance. So we've talked a lot about the stakes of having these unfair contract terms, but what actually are they? What are some examples of things that you might see in practice or have inside your agreements? So we'll go through a few different examples. We have fee variation traps, ways that people might want to change or adjust their fees without necessarily getting approval. We'll talk about one-sided liability clauses. This is probably the most common issue that I've seen in agreements that needs to be changed, and then termination or exit clauses. These are like some of the most common unfair contract terms in small business agreements, but they're not the only ones. And again, depending on your agreement, there may be other sorts of issues. And again, the definition of unfair terms, it's not like there's a laundry list in the legislation of exactly what's unfair. It just is this test. Is it too one-sided, and that one-sidedness is not necessary, and if enforced it would cause detriment to the other party? That's kind of the test. Helpfully, the ACCC does provide a bunch of examples to help elaborate, and again, some of these are taken from the ACCC examples, but it's up to ultimately someone to make an argument that something's one-sided, and potentially it could be interpreted that way if they can tick the three-part test. So let's look at the first case study, and this is based on a real ACCC case with Servcorp. We have a software licensing contract which allows the provider of the software to increase the fees without prior notice and without offering the customer the option to terminate the contract. So the clause in question here, which is something that I've seen in many terms and conditions, and you may go have a look at some of your software subscriptions that you might use for your business. Certainly when the laws came out, I had a look at Sprintlaw's software licenses with our CRM provider and our task management provider and a few other, and some of the companies were based in the US but operating in Australia, and they had clauses like this which were in breach of the Australian unfair contract terms laws. And in some cases, I actually reached out to them and they tried to raise the fees. And, I said, you may not realize this, but you're in breach of these laws. And I got the fee increases reversed. So this is an example of how you might be able to use it in your favor, particularly if you're dealing with international companies. But yes, this clause, we reserve the right to change the fees from time to time. We will notify you in advance if we do this. A common clause that software companies use. And, they just send you a message, hey, the fees are going up. Sorry, now you have to pay more. Presumably many of you have received an email like that. If it's a standard form contract, which it usually is for software companies, if you've just had to tick and agree it when you signed up, this is an example, pretty black and white, of what may be considered an unfair contract term. And really, the clause has to be written more like what we have on the right. We reserve the right to change the fees, but if we do this, we'll give you at least 30 days notice. And doesn't matter if you're on an annual contract or a monthly contract or whatever, when you get the notice, you are able to terminate immediately. And if you keep using it afterwards, then you are consenting to the change in fees. So this is a more balanced version. Now, the best version for the customer would be, if you want to increase the fees, you got to ask me and I have to click a button to agree. But operationally, for a software company that might have thousands of customers, if they're big, for them to get everyone to click a button agreeing to the new terms might be too logistically complex. And so, we said earlier, this is still a little bit one-sided for the software company because they still basically say, if we don't hear from you, we're just going to raise the fees. But they've given you early notice. They've told you got the right to cancel. And they would argue that this little bit of imbalance is necessary to protect their legitimate interests because it would really ruin their business if they had to contact every single customer and get them to agree to a new deal. And given that, this new clause, I would argue, is much lower risk of being unfair, if that makes sense. So you can see in this example, the one on the left is pretty clearly unfair. The one on the right is much more balanced. And we've also seen, even though it's a little tiny bit one-sided, we've also seen that you might be able to argue that that's okay, given the legitimate interest test. So something to be thinking about with these clauses. A couple of comments. Di's mentioned, I've received plenty of these notices. I just assumed they were legal. Yes. Again, I think when these laws came out, and this is in part because a lot of the software companies are US software companies who, believe it or not, have not gotten local Australian legal advice. They're not aware of these changes and are certainly, in my view, breaching some of the unfair contract laws with the way they work. Now, as I have said with the clause on the right, some of them are probably giving you reasonable notice. Google recently did, I think, an update to a lot of their business plans. And if you were a lawyer and carefully looked at how they did it, they gave a lot of early written notice and included some wording like we have on the right here before they did their price increase. So, they followed closer to best practices, but a lot of the smaller software companies are just saying, too bad the price is rised. And again, that's the kind of thing that could potentially be, or I would say even is likely to be unfair. Di said, is this information relevant to employment contracts and contractor agreements, or is this a separate webinar? I've got a couple of contractors working with me, and I was wanting to make sure our agreements were in alignment with the law. That's a good question. Employment contracts have a separate regime that's very similar in nature in terms of unfair terms, but employment contracts are a little bit of a different beast. I did a webinar not too long ago on employment contracts, so you can watch a recording of that if you sign up to the Sprintlaw platform or check out our YouTube channel. I talked a little bit about those, but with employment contracts, it's not, there's a lot of other laws that you've got to navigate in addition to the unfair terms. Contractor agreements, though, are largely not governed by employment laws because contractors are, with some exceptions, which I won't go into right now to keep it simple. Contractors are in general not employees. They are kind of separate businesses, sole traders, or companies that you're dealing with. So contractor agreements definitely fall under this regime. And again, many examples of agreements we've seen between businesses and contractors where the business says, take it or leave it, this is our standard contractor agreement, and the contractor signs up. If the boxes are ticked, it's a standard form contract. There was no opportunity to negotiate. The contractor is not is a small business, et cetera, then again, the contractor could allege that the terms are too one-sided, and certainly, again, at Sprintlaw, we have relationships with contractors and in fact have some standard form agreements that we used, and right after the laws came into force, or prior to it really, we changed the wording of those agreements to make them more balanced. So yeah, you should definitely have a look at those contractor agreements is the answer to that question. Case study 2. This is a bit of a different one. We have a landscaping contract that allows the landscaper to avoid liability for any damage to the client's property due to their own negligence. So a bit of a different situation. You hire someone to do some landscaping, and the landscaper's agreement says, if I break stuff, sorry, too bad, your problem. Any damage caused to the client's property, whether by act or omission of the landscaper, will not result in any liability, financial or otherwise, on the part of the landscaper. The client fully assumes all risk of damage and loss related to the landscaping services provided. So again, if the landscaper hands you a terms and conditions, you sign it. Maybe you are the landscaper, but assuming you're the client in this scenario, hands you the terms and conditions, you sign it. You don't really read it, and they break, you know, a ton of property and say, sorry, too bad, it's all at your risk. This is pretty one-sided and would potentially be an unfair term. Now, on the other hand, a landscaper couldn't do business if a landscaper was landscaping, someone's house and they damage something and now they're liable. It's $1 million vase or something. They're liable for $1 million. They're out of business or whatever it is. So the law isn't so, it doesn't require you to go so far in the other direction where the business takes all the liability. But equally, if it tries to take no liability, it's not very balanced. We have this nice picture of the balance on here. So it's a good way to visualize this. So what we would suggest for the landscaper's contract here is to say the landscaper will do their best to not damage the property. If there is any damage through negligence of the landscaper is happy to be liable, but the total amount the landscaper will ever be liable for is up to a maximum of $5,000. So you set a dollar cap, or maybe you make it a refund or 3 times a refund or something, but you set a cap on the liability. This way, the landscaper is accepting some liability, but not so much liability that it would be business ending for the landscaper. And again, we come back to this 3-part test. We've gone from landscaper has no liability, which would be a significant imbalance, to landscaper will have some, but not too much liability. Now we're starting to get some more balance. The landscaper says, I need to have some protection or I can't do business. Otherwise, it's too risky. While the original version would cause detriment to the client because they would have no claim, this at least gives them some recourse. So this is the kind of change that we're talking about. And again, if you've got the one on the left, more likely to be unfair, fined and penalized. You've got the one on the right, far lower risk of being one of those unfair contract terms. Case study 3 we have here is a catering services contract that imposes fines on clients for cancelling their catering services before the contract term ends, while permitting the caterer to terminate the contract at their discretion without incurring any penalties. So the wording of the clause that may be unfair is on the left here. If the client cancels the catering services prior to the end of the contract term, a cancellation fee equivalent to 50% of the total contract value will be imposed. The caterer reserves the right to terminate this contract at any time for any reason without any obligation or penalties. So this is something that we see a lot in event-related services, or when someone orders something in advance. The person who's providing the event-related service says, look, I'm booking you in, and now I can't take any other bookings that day. So, you basically got to promise me you're not going to cancel. And if you do cancel, I still get the money, even though I won't have done anything, just for the right of you having secured my time. But then often the event-related service, in this case catering, wants to say, but if I cancel because I get sick or I can't do it, too bad, I'll have no penalties. So again, you can see here, it's pretty unbalanced. The client has to pay big money if they cancel, but the service provider doesn't have to pay anything if they cancel, or at least there's no consequence. So now, on the other hand, it is a legitimate comment for the caterer to say, if you cancel the day before, I've already ordered all the food, I've ordered all the supplies, and you can't just pay me nothing. Like, I need some cancellation fee because otherwise I'll be out of pocket. So again, we're not trying to be super harsh on the caterer here. We're just trying to be not too balanced in favor of the caterer. So again, a common change we would make to this kind of clause is what you see on the right. If the client wishes to cancel the catering service prior to the end of the contract term, a cancellation fee will be imposed as follows: X% if cancellation is more than Y days before the event, Z% if the cancellation is less than Y days before the event. So here we might say it's 50% or 80% or even 90%, you might say, if it's less than 24 hours before the event. It's 50% if it's a week before, and it's only 10% if it's more than a week before, because maybe the caterer then didn't have to incur the costs or whatever it is. Something like this presents much better. It looks more balanced, it ties the amount of payment to the likely losses of the caterer while still protecting the caterer. And again, you can see the one on the right is likely to be far less likely to be seen as an unfair term than the blanket one on the left. And then we have this second paragraph. If the caterer is going to terminate the contract without a valid reason, such as an act outside their control, force majeure we call it, like COVID or something, or non-payment by the client, then the caterer will refund the client any prepaid amounts, and but still might be able to keep some. So again, the caterer, if they cancel, has to at least refund any money that they've pre-collected. So you can see how that becomes a lot more of a balanced clause. Moving now to auto-renewal clauses. Another common thing people would have seen. A gym membership agreement that automatically renews at the end of the initial term without obtaining explicit consent from the member, making it difficult for them to cancel. For those of you, and I'm one of these people who've signed up to gyms, you often find that it's very difficult to get out of your gym contracts, and they, will often automatically renew, and you find yourself paying without really realizing it. And so again, some of these terms that are buried inside the gym terms and conditions, are at now risk of being unfair. And there's a ACCC case, not for gyms, but for a hamper business that did something similar, which really talked about this issue. So in the past, this clause might have said, at the conclusion of the initial membership term, this agreement will automatically renew for successive periods equal to the initial term. The member will continue to be billed at the current rate unless they provide written notice of non-renewal within 5 days of the end of the then current term. So what we're saying in this scenario is, you've signed up for a year membership, let's say. You've got you've got to tell us with more than 5 days notice that you don't want to renew, otherwise you've signed up for another year. Again, this is what we are colloquially referring to now as lawyers as subscription traps. So people sign up to the subscriptions and then they don't realize that the renewal's going to happen. Now, on the other hand, it's probably core to pretty much any business's subscription model that they have automatic renewal. Again, we give the example of the software company that it would be impractical for them to reach out to every single person, have a chat to them and get their express approval. It becomes untenable for the business to run if it can't have automatic renewals, at all as a concept. So again, we're trying to work out a way to protect the business's interests in wanting to keep auto renewals as part of their business model, in this case, the gym, but not have it be so harsh that the customer is tricked into renewing with no recourse. So we have on the right here, at the conclusion of the initial membership term, the membership will automatically renew for successive periods equal to the initial term. However, members will be provided a 30-day grace period from the start of the renewed term to cancel their membership and receive a full refund. The refund can be claimed by contacting us at this address and will be issued within 30 days of receipt. We'll send a reminder notification to the member at 30 days prior to the end of the term, informing them of their automatic renewal and their rights regarding the grace period. So here again, we have still got the automatic renewal, but it's much more reasonable. If for whatever reason the member misses the notification, sees the bill on their bank statement and has an issue with it, they've got a 30-day grace period so they can get out of it. If the gym's also committing to telling them in advance that the renewal is coming, to remind them that it's coming up, so it's not a hidden charge, but they're still able to have the automatic renewal without needing to contact the customer. Something on the right would be far more likely to be acceptable than something on the left, where people are tricked into renewing and then can't kind of get out of it. So again, for those of you with renewal models or retainer models or subscription models, it's something to think about. Now, all this grace period reminder concept, maybe you don't need that for monthly retainers as opposed to annual retainers, because again, Customers are usually much more aware of how monthly retainers work. So I'm not suggesting that every form of automatic renewal has to have grace periods. But what you want to be thinking about is almost from a reasonableness perspective, what's fair in the circumstances, what is, what's the customer going to be, um, sort of what are they going to have knowledge of at the time of the automatic renewal, and have you kind of tricked them by bearing something in the fine print or really put them on notice that this is coming? And I think these are the kinds of factors, at least looking at this case with the hampers, that that the ACCC will look into account. And again, without going into great detail about this case, a lot of the commentary and the decision here against Crisco hampers was around the fact that notice wasn't given, grace periods weren't given, and it just kind of happened and a refund wasn't offered. So a lot of that can go a long way to making these automatic renewals something that can work for your business. And I guess for Sprintlaw, we have ourselves an annual subscription, and we have an automatic renewal concept, but it's important in our terms and conditions, people can cancel at any time and turn off the automatic renewal, and it's not too difficult to do so. And we kind of have a grace period policy for people that renew and didn't really realize, it was definitely relevant to our business in terms of thinking about these things beyond the terms and conditions, but also in the way that you might actually set up the business operationally. So those are, I think, some good examples that hopefully give you a flavor of the kinds of concepts that might be too one-sided. Ultimately, for your business, you may not have automatic renewals, or you may not have events coming up with cancellation policies. What you want to be thinking about is, my contract is probably designed to protect me. Is there anything in there that's a little too one-sided, a little unfair? And can I come up with a way of doing it that is not so unfair, but still protects my legitimate interests, if that makes sense? And so something to think about for your business, and again, something that you may potentially work through with a lawyer. And again, on the other side, it's not necessarily just about your terms and conditions. It might be about contracts that you agree to or have agreed to. You have the right, even with big companies, to ask for terms to not be unfair, to complain if they are unfair. And if people are trying to do things or implement practices where they're just raising the price without telling you, or they're pointing to things in their terms and conditions that are really unfair that you didn't know about, even if you've agreed to them, even if you signed off on them, you may still be able to make a claim or a case that they're unfair. So it's important to know your rights too, as a customer, not just as a service provider. But we have on this slide, I think, maybe the key steps for people to think about. I mean, the first one is get your terms and conditions checked by a lawyer. I mean, if you, particularly so if you used a sort of generic online template, chances are it may or may not even be an Australian template that you used. So, if it's an international template, it certainly won't have the right language. But even if it's an Australian template that you used, these laws have made it more difficult for small businesses to rely on templates for their customer contracts, because as you hopefully have picked up from these examples, whether something is okay or not depends heavily on the clause, the business, what type of business you are, and what your actual interests are. And so a template doesn't know all about you. And it might be that you've got something in your terms and conditions that's from a template that's been, checked by somebody, but might actually, when used for your business, be unfair. And because there's penalties now, you just want to make sure you get it right. So again, if you had it prepared before September 2023, or if you've used a template and you're not sure it's up to scratch, I'd suggest getting it checked because the stakes are higher. Know your customers. Again, it's always important to remember, because we do get people asking us about this, that this doesn't apply to every single contract that you sign. It's only the standard form ones that you're sending out. If you're negotiating contracts or a one-on-one deal with a developer or whatever it is for your business, you can pretty much agree what you want within the bounds of other general legal requirements. It's just for these standard terms and conditions, and it's only for the smaller businesses. So you just want to make sure is my customer actually a small business, or are they a big business, and do they meet the test? So we've got this concept of just know your customers and understand if this law applies to them. It probably does, given how broad it is. Think about setting up a contract compliance process. So you would have signed contracts with many customers in the past. you may be signing contracts with many customers in the future, you want to make sure that you know which version of your contracts your customers have signed. Ideally, you want to get all of your old customers on your new terms and conditions. If you're thinking to yourself now, oh man, I've got terms in my contract that might be too one-sided, and I've been using it for the past year or the past 6 months or the past 5 years or whatever it is. Um, there are ways for you to get an updated terms and conditions and just notify them of the change and get them to agree to it in a straightforward way. But you might want to set up a spreadsheet or a checklist or some way of making sure that you've ticked the box and there's no one out there that has these unfair terms. And finally, it's important, anyone in your business, whether it's you running the business or if you have employees who are signing people up, you want to make sure, or dealing with customer complaints, you want to make sure that they're aware of these unfair contract laws. One pitfall that we see in a lot of the cases that have ended up going to ACCC is people had unfair contract terms in their contract. The people in the business didn't realize that they were unfair and basically, were firm with customers and said, I'm sorry, we're not giving you a refund here. This is what our terms and conditions say. And the customer said, but you're breaching these laws, blah, blah, blah. And then, the business will say, no, we had it checked by a lawyer, it's fine. And then the customer goes and complains to the ACCC. My advice often is if people are getting upset or alleging terms unfair, you should take it really seriously as a business because you don't want a complaint to go to the ACCC. And so you want to make sure that your team is aware that there are legal risks with enforcing your contract in ways that might be unfair and appropriately escalate it. And oftentimes it might be simpler to just give that refund rather than run the risk of a complaint going to the ACCC, particularly if it's for a clause that you have that might be unfair. So it's great that everyone's here getting a little bit aware about these laws. And again, I think it's important for people across your organization to at least have some awareness that the stakes are pretty high if you are trying to use stuff in your terms and conditions in your fine print that might be one-sided. So that was the majority of the content I wanted to cover on these unfair contract terms. If anyone has any questions, I'm happy to stick around for a few minutes and answer them. But hopefully people have found that useful. And again, we'll have a second look at contracts that you're asked to sign and also a review of your own terms and conditions to make sure that there's nothing in there that's too one-sided. And again, if you want our team to have a check, do feel free to email us or book in a call, and we'd be very happy to help. It's got a question that has come through. Are indemnities now harder to enforce at a matter of practice, simply no longer around? Is there ever a legitimate reason to have one? Excellent question, and certainly one that we've had really debates internally with our legal team about when and how to use indemnities. I would say that indemnities, for those who don't know what indemnities are clauses that are in contracts which often one party says to the other, I promise to cover you if XYZ happens. So for example, it might say, if I'm developing software for you, turns out I stole that software from someone else, and gave it to you, I promise that I, the software developer, will indemnify you, will cover you if you get sued as a result of my bad work. So any money that you're liable for in the end, I will cover every cent of it. That's what an indemnity is. So it's almost like an insurance policy from one party to the other if something goes wrong. And they're really nice to get if you're getting an indemnity because you go, okay, I've engaged a software developer. I know that if they did anything dodgy, they promise to cover all my costs. But they're very one-sided and often can be very bad for the person giving the indemnity. So I think the current view on the indemnities is, it depends on the circumstances. It depends if it's required to protect the legitimate interests, et cetera, et cetera. They are usable sparingly, but it has to make sense. I'll give you an example of one. We did a contract for someone who was providing services at weddings, like a photographer, videographer service. And in their standard terms and conditions, they wanted to have a clause in there that said, if there is any inappropriate behavior of guests, someone has too much to drink and injures the photographer or whatever it is, they'd asked the client to indemnify them for, any issues, losses, personal injuries suffered by the photographer. In that circumstance, I think it would be seen to be a reasonable, even though it's pretty one-sided because the customer, if the photographer gets injured because one of their guests hurts the photographer, the customer could be liable for lots and lots of money. It will be probably seen to be reasonable in the circumstances because, issues happen at these big events, and it's reasonable for the photographer who doesn't have control over the guests or the venue to ask for that. So you could ask for a specific indemnity in a circumstance where you're very concerned. But some of the old strategies lawyers used where it just said, you will indemnify me for anything that goes wrong if I suffer any loss of any kind, stuff like that, I think is not used in these standard form contracts as much anymore and is quite risky. So a bit of a nuanced answer to that question, but hopefully it makes some sense. If anyone has any other questions, I'm happy to stick around for another minute or two. Okay, all good. Well, again, hope you found this useful. We do these every month, so please do sign up and come along again. If there's ever topics that you want to hear about, we're happy to cover them. Otherwise, it's been great to run through this and wishing you all the best. Oh, we've had one more question come through. I may as well answer it before I drop off. In the earlier slide, you outlined some formulas for early termination or cancellation. How do we practically figure out what costs I should consider or percentages for early termination? There's not a black and white answer to that question. And let me put it this way. Because as I outlined at the beginning, the unfair contract laws are by nature subjective. It says, is it necessary to protect your legitimate interests? Is it unbalanced and will it cause detriment? These are all very arguable terms that a lawyer could argue either way. The answer to your question is the lower the percentage that you bill the client, the lower risk it is. The more that you're trying to take, the higher risk it is. So what you kind of have to figure out is almost from a common sense perspective, what's reasonable, and furthermore, not just what's reasonable, what are my actual costs that I'm incurring? And if you can tie it to something tangible like that, you can say, look, take the catering example. If you cancel less than 24 hours before, I will have already incurred half the costs of doing the job. So that's why it's 50%. If you tried to charge 95%, that might be unfair because you're really getting a bunch of money for free without doing anything. Now, of course, there's the opportunity cost of another booking, so maybe you value that. But if you can tie the percentages to something tangible in terms of what you've actually lost, what the cost was, then it brings the risk right down. And again, even the fact of having a formula in there that has the stages, you can just imagine it's put in front of a judge and they see, okay, this person put some thought into this clause. They put in different stages. The numbers look roughly reasonable. It's very unlikely the judge will see it to be unfair. So I can't give you exact numbers, but I can give you that framework. Try and tie it to something tangible. Don't make it too aggressive. And again, a lawyer can help you work out exactly what those numbers should be. But that's definitely the right way to think about it. Miles has asked, if T's and C's are not provided by the supplier, what happens if there is a dispute? That's a bit of a different scenario. We're talking about situations where someone's given you a standard terms and conditions and there might be problems with it. Sadly for us as lawyers, many times business is done without a contract at all. If no contract is done, these laws in a view aren't relevant because there's no terms that could be unfair. And in general, if you have a dispute between two parties with no contract, one party can just sue the other, and the party who provided a service is at pretty big risk because they haven't put limits on their liability. So if they've caused you damages or losses, you could potentially sue them. On the other hand, if you never agreed exactly what they were providing, you never agreed how the fees and payments work, it's risky for you because you can't say that they didn't do what they promised if you haven't got evidence of what they promised. So probably if you're in a significant dispute, you need to go chat to a lawyer and untangle the situation and figure out what your rights are. But the moral of the story is generally try and do business with terms and conditions if you can. It'll make it a lot clearer as to what would happen. Fantastic. All right, guys. Well, thank you all so much for coming. And again, hope to see you at one of our future webinars. But it's been great to chat. See you later.